Hello and welcome to The Print. This is Khadija Khan, and today I'm going to tell you about a landmark decision of the Supreme Court which broadens the contours of personal liberty. The Supreme Court on Thursday ruled that informing the arrestee about the grounds of arrest is mandatory for all offences in a language which they can understand. By way of a 52-page ruling, the two-judge bench reasoned that informing a person of the grounds of arrest is a mandatory requirement under Article 22, Clause 1 of the Constitution and must be conveyed in such a way so as to achieve the object of the constitutional safeguard. The provision specifies that no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such an arrest. The court also relied on provisions of law under different statutes like Section 50 of the CRPC or the Criminal Procedure Code 1973 and Section 47 of the Bharatiya Nagrik Suraksha Sanhita 2023, which also mandate that the grounds of arrest must be communicated to the arrestee or the one who's being arrested at the earliest possible instance. A bench of Chief Justice of India, B.R. Gavai, and Justice Augustine Massey also said that while it is preferable that these grounds are given in writing, if due to some reason one is unable to communicate the grounds of arrest in writing or soon after the arrest, it must be done orally. For instance, if a policeman sees a murder being committed, it may not always be possible for him to provide the grounds of arrest in writing before the arrest to the accused. A rigid insistence upon informing of the written grounds of arrest before or at the time of arrest could also hamper the policeman's ability to do his job properly, the court noted. Even then, the court said that the grounds must be communicated to the accused in writing within a reasonable time, and in any case, at least 2 hours before production of the arrestee for remand proceedings before the magistrate, the two-judge bench said. Court was acting on a plea filed by one Mihir Rajesh Shah, the son of a politician who was accused in the high-profile BMW hit-and-run case in 2024 in Mumbai, where a woman succumbed to her injuries and lost her life. After the Bombay High Court denied him bail in November last year, he approached the Supreme Court with the present appeal, which dismissed his plea but gave the present ruling on the larger question of law. Relying on its previous 2024 rulings in Prabir Purkayasta's case and Pankaj Bansal's case, the court held that supplying the accused with the grounds of arrest in a language which they can understand is essential and is in line with the constitutional mandate. Carving out an exception for special statutes like the PMLA or the Prevention of Money Laundering Act, the court said in cases involving offences which are primarily based on documentary evidence or records and economic offences like those under the PMLA, the grounds of arrest can be furnished in writing to the arrested person on arrest simultaneously. We thus hold that in cases where the police are already in possession of documentary material furnishing a cogent basis for the arrest, the written grounds of arrest must be furnished to the arrestee on his arrest, the court said, while adding that in exceptional circumstances such as offences against the body or property where informing the grounds of arrest in writing is rendered impractical, it shall be sufficient for the police officer or other person making the arrest to orally convey the same to the person at the time of the arrest. The court also said that failure to adhere to this procedure could nullify the arrest, leaving the accused at the liberty to be set free. However, even in such cases, if the authorities later on furnish the grounds of arrest in writing in the manner prescribed, they can seek custody of the arrestee. That's all for today. For more legal updates, keep watching The Print.